Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court taken into custody.
Really? That's it.
This hearing is chaotic from the moment it begins. Mr. McLeod is facing a charge for allegedly assaulting a police officer, but instead of cooperating, he insists the court has no authority over him. He uses arguments that have no legal basis, interrupts constantly, and throws out terms that don't apply. Despite that, the judge stays calm and tries more than once to give him a fair chance to participate properly. But the situation gets heated, and eventually the judge has no choice but to place him in a holding cell for the night. It's a frustrating hearing to watch, but also a reminder of how quickly things can fall apart when a defendant refuses to follow basic courtroom procedure.
Do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay.
Here, by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Pay close attention to how patient the judge is. Even with constant interruptions, the judge keeps trying to guide Mr. McLeod through the process. It's almost impressive how long he maintains that patience while Mr. McLeod continues insisting he doesn't understand simple legal concepts. Let me know in the comments whether you think he genuinely believed what he was saying or if he was trying to avoid taking responsibility.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No. So,
hold on. I guess a couple things, or I'm going to be in trouble. Okay. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So I
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what
I
it
don't
is you don't
understand the
understand?
nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney would, Drew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing.
There's also an unexpected moment in the courtroom that catches everyone off guard and lightens the mood for a split second. It's surprising, but almost reflects what everyone in the room is thinking about how off-track the hearing had become. It also makes sense why his attorney asked to withdraw. Mr. McLeod keeps flipping through a stack of papers, as if he's looking for something that will instantly solve the case, even though none of it applies. Meanwhile, the judge, prosecutor, and everyone else clearly already know how this is going to end. But he keeps pushing forward, acting like he has found a special loophole that will change everything. You have to wonder what people who use these unsupported legal theories expect the outcome to be. Courts follow established law, not personal interpretations. So these arguments never work.
One second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I've challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
jurisdiction doesn't exist under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on.
At this point in the hearing, you can tell the judge has reached the end of his patience. Mr. McLeod is still reading from papers that don't relate to the case, and the judge is addressing him calmly, directly, and professionally, making it clear what the law actually requires. Moments like this really show why judges have to maintain control of the courtroom.
I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
your
McLeod,
statutes.
I have other matters. Mr. McLeod,
Involved agency. What's that?
you know, I understand you want to object to things and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
No, Your
and then
Honor,
we'll
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws. I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
do you comprehend the maximum penalty that you would face?
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal.
There's
it
no
to the
such
Michigan
thing as
Court
a
of Appeals.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question or I'm going to hold you summarily in contempt. And the court officer will bring you to a jail cell and we'll talk about it tomorrow. You understand that?
So
Mr. McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine.
I don't understand the charges. I
Mr.
understand.
McLeod is in
Seven
contempt of
charges.
court, taken into custody.
Really? That's it. Protecting my rights is what I'm saying.
Fucking Joe.
This isn't true. You guys
You'll
are
have to follow
following
unconstitutional
You're following
orders.
unlawful orders. It's not
Not a
constitutional at all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
Watching Mr. McLeod try to represent himself is difficult. Instead of using his right to an attorney, even a free court-appointed one, he tries to handle everything alone. The judge goes out his way early on to explain things clearly, but there's only so much he can do before he has to move the hearing forward. What makes it even more concerning is how confident Mr. McLeod seems while moving further away from helping his own case. He's charged with a serious offense, one that can be classified as a felony and carries several years of potential prison time. Instead of addressing the charge, discussing a possible plea, or offering a real defense, he keeps relying on arguments that the court cannot legally accept. This approach has been rejected for decades. Courts are required to follow the law, not theories or documents that have no legal standing. By refusing to participate properly, he risks making the situation worse. A felony conviction can mean prison time and the loss of certain civil rights in the future. All of this could be avoided or at least handled more effectively if he simply worked with an attorney and followed standard procedure. That wraps up this breakdown. Let me know in the comments what you think about Mr. McLeod's behavior. Do you think he truly believes what he's saying, or is he trying to avoid accountability? Don't forget to like and subscribe for more Courtroom content. Thanks for watching and take care.